Recipients of Genesee Health System have specific legal rights set forth under various laws, including Michigan's Mental Health Code and the Department of Community Health Administrative Rules. A recipient is defined in the Mental Health Code as an individual who receives mental health services from the department, a community mental health services program or a facility, or from a provider that is under contract with the department or a community mental health services program. Recipient rights refers to special legal rights that recipients of community mental health services have. Recipients receive notice of their rights through the Your Rights booklet, which is provided to them when mental health services are first requested. The Mental Health Code requires that each community mental health services program establish an Office of Recipient Rights, or ORR. The functions of the ORR are basically divided into 4 areas: complaint resolution, education, prevention, and monitoring. The ORR receives recipient rights complaints and may independently open complaints of suspected, alleged, or apparent recipient rights violations as well. Anyone can file a complaint, including a recipient, guardian, family member, staff person, or member of the public. A complaint can be filed in person, by telephone, sent through the mail, or by fax. When a recipient rights complaint is received, 3 questions are asked in order to determine whether or not the complaint is appropriate for the ORR. Number 1, is the individual whose rights were allegedly violated a Genesee Health System recipient? In order for the Genesee Health System ORR to become involved in a recipient rights complaint, it must involve a Genesee Health System recipient of services. Number 2, is the complaint about some aspect of the recipient's mental health services? In order for the complaint to be appropriate for the ORR, it must involve some issue involving the recipient's mental health services. That is, something that Genesee Health System is paying for in some way. Number 3, does the complaint involve a mental health code protected right? In order for the complaint to be appropriate for the ORR, it must involve a legal right to which the recipient is entitled as a recipient of mental health services. Protected rights are those outlined in the Your Rights booklet. The chart in the handouts included with this training, entitled Mental Health Code Rights, Categories, also details the rights to which recipients of mental health services are entitled. What exactly is a right? Black's Law Dictionary defines a right as that which a person is entitled to have, to do, or to receive from others within the limits prescribed by law. That is, a right is something that must actually be provided for in the law. For the most part, the investigation process is utilized by the ORR. Note the chart in your handout entitled The Recipient Rights Complaint Process. ORR investigates alleged, apparent, or suspected recipient rights violations in a neutral and impartial manner in order to make an appropriate determination as to whether or not a recipient's rights were violated. The Mental Health Code provides ORR staff with access to any evidence necessary in order to conduct a thorough investigation. This includes access to documents, staff, applicable service sites, and recipients. Staff are required to cooperate for agency policy and applicable contracts. The Mental Health Code permits 90 days for the completion of the recipient rights investigative process. An investigative report is completed at the conclusion of the investigation and submitted initially to the Executive Director. The ORR's conclusions are based upon the preponderance of the evidence, which means evidence which is of greater weight or which as a whole shows the fact sought to be proved is more probable than not. Where there is a preponderance of the evidence that a recipient's rights were violated, it's referred to as a substantiated recipient rights violation. In the cases of a substantiated recipient rights violation, the respondent must provide the ORR with his or her corrective action plan, referred to as remedial action. A respondent is the provider who had responsibility for the services about which a rights complaint was filed. Remedial action must attempt to correct the rights violation, prevent its recurrence, and be implemented in a timely manner. For cases of substantiated abuse, neglect, harassment, or retaliation, The remedial action must be disciplinary in nature. The following individuals have standing to appeal a recipient rights investigative summary report within 45 days of its receipt: the complainant, the recipient, and where applicable, the recipient's guardian or the parent of a minor recipient. The Mental Health Code states, recipients of mental health services shall not be subjected to abuse and neglect. See the handout included with this training for detailed definitions and hypothetical examples of abuse and neglect. If a case of abuse or neglect is substantiated, the Mental Health Code requires disciplinary action be taken as a result. There are 3 classes of abuse and 3 classes of neglect. Class 1 is the most serious. Specific definitions and hypothetical examples are provided within the handouts included with this training. Definitions in related detail are also provided within Agency Policy 0800595, Identifying and Reporting Abuse and Neglect. Please read each. Abuse Class 1 is a non-accidental act or provocation of another to act by an employee, volunteer, or agent of a provider that causes or contributes to any of the following: death of a recipient, serious physical harm to a recipient, or sexual abuse of a recipient. Sexual abuse is defined as criminal sexual conduct involving an employee, volunteer, or agent of a provider and a recipient, any sexual contact or sexual penetration involving a recipient and an employee, volunteer, or agent of a facility licensed by DCH, a department-operated hospital or center, or an adult foster care facility, any sexual contact or sexual penetration between an employee, volunteer, or agent of a provider and a recipient for whom the employee, volunteer, or agent provides direct services. Some types of sexual abuse allegations also need to be reported to the police. Abuse Class 2. There are different definitions of Abuse Class 2, designated as letters A through E in the materials included with this training. The first definition under letter A states that Abuse Class 2 is a non-accidental act or provocation of another to act by an employee, volunteer, or agent of a provider that causes or contributes to non-serious physical harm to a recipient. Under letter B, the second definition states that Abuse Class 2 occurs when a staff person uses unreasonable force on a recipient. Unreasonable force is physical management or force that's applied by an employee, volunteer, or agent of a provider to a recipient in one or more of the following circumstances. There's no imminent risk of serious or non-serious physical harm to the recipient, staff, or others. The physical management used is not in compliance with approved techniques. The physical management used is not in compliance with emergency interventions authorized in the recipient's plan of service. The physical management or force is used when other less restrictive measures were possible but not attempted immediately before the use of physical management or force. Additional definitions of Abuse Class 2 include, under letter C, any action or provocation of another to act by an employee or volunteer which causes or contributes to emotional harm to a recipient. Under letter D, an action taken on behalf of a recipient by a provider who assumes the recipient is incompetent, but no guardian has been appointed, that results in substantial economic, material, or emotional harm to a recipient. Under letter E, exploitation, any action that involves the misappropriation or misuse of a recipient's property or funds for the benefit of an individual other than the recipient. Abuse Class 3 is the use of language or other means of communication by an employee, volunteer, or agent of a provider to degrade, threaten, or sexually harass a recipient. Neglect occurs when a staff person fails to follow a standard of care, which could be failure to follow a law, policy, guideline, directive, established procedure, physician order, or individual plan of service. And the failure to follow the standard of care causes or contributes to either death, physical harm, sexual abuse, emotional harm, or risk of harm. Neglect is commonly characterized as a staff person doing something they shouldn't have done or not doing something they should have done in non-compliance with some standard of care. In addition, a staff person's failure to immediately report an alleged, suspected, or apparent act of abuse or neglect is considered neglect. That is, failure to report abuse or neglect of the recipient is considered neglect in itself. Remember that the required reports of abuse or neglect to ORR are those associated only with the recipient's mental health services. That is, a report that an individual working at a department store has mistreated a client, for example, is not appropriate for ORR because Genesee Health System has no contract with the department store and the store employee is not providing mental health services to the recipient. Neglect Class 1 occurs when a staff person fails to follow a standard of care that causes or contributes to death, serious physical harm, or sexual abuse of a recipient. It's also Neglect Class 1 for failure to report alleged, apparent, or suspected abuse Class 1 or Neglect Class 1 of a recipient. Please see the hypothetical examples of Neglect Class 1 in the materials accompanying this training. Neglect Class 2 occurs when a staff person fails to follow a standard of care that causes or contributes to non-serious or emotional harm to a recipient. It's also considered Neglect Class 2 for failure to report alleged, apparent, or suspected abuse Class 2 or Neglect Class 2 of a recipient. Neglect Class 3 occurs when a staff person fails to follow a standard of care which either placed or could have placed a recipient at risk of physical harm. It's also considered Neglect Class 3 for failure to report alleged, apparent, or suspected abuse Class 3 or Neglect Class 3 of a recipient. The reporting requirements around abuse and neglect are stringent in order to best protect the recipient. The allegation of abuse or neglect may be factual, therefore immediate reporting and subsequent action must occur to prevent it from continuing or recurring. Staff must report any apparent, suspected, or alleged rights violation. This includes something that someone else told you about, regardless of whether you believe he or she is telling the truth, because it's still considered an alleged rights violation. For allegations of abuse or neglect, staff must make an immediate verbal report both to the Office of Recipient Rights and a supervisor. Often the supervisor is in the position to take immediate action related to the allegation. If it's after hours, it's both necessary and appropriate to leave a voicemail message on ORR's voicemail box. Immediate does not mean reporting at the end of the day, at the end of a shift, or the following Monday if the alleged incident happens on a weekend. Immediately means immediately. Keep in mind that some allegations are factual, and in that case, no one would want mistreatment or inappropriate care to continue until the end of the day, the end of the shift, or until a weekend passes, or to recur during that period. In addition to the verbal report, staff should document allegations of abuse and neglect on a critical incident report. The verbal report must be completed immediately. The written critical incident report may be completed after the verbal report. However, completion of the incident report does not override the requirement of the immediate verbal report. Failure to report abuse or neglect is considered neglect and is therefore a violation of state law as well as agency policy. For any other alleged rights violation, that is, non-abuse or neglect allegations, staff must make the verbal report within 24 hours. However, the most protective course of action is to report any apparent, suspected, or alleged recipient rights violation immediately. Let the ORR decide what is or isn't properly categorized as abuse or neglect. When it comes to reporting abuse and neglect allegations, remember, a verbal report is required immediately. The verbal report must be made to both the ORR and your supervisor. Even if it's after hours or a holiday, call and leave a message on the ORR's voicemail. Agency policy protects recipients, staff, and anyone else acting on the behalf of a recipient from harassment and retaliation related to their involvement in rights issues. The definition of harassment is defined as words, gestures, or actions which threaten an individual, attempt to intimidate, coerce, or inappropriately influence those involved or who may be involved in recipient rights activities, unreasonably interfere with an individual's work performance, or create an intimidating, hostile, or offensive situation. Cases of substantiated harassment or retaliation as a result of rights activities also require disciplinary action. The second handout that's included with this training is entitled Mental Health Code, Chapter 7, Recipient Rights Summary. Please review this handout in its entirety. Note under Section 706, Notice of Rights, that applicants and recipients must be provided with a summary of their rights at the time services are first requested and periodically thereafter. This is accomplished by providing the Your Rights booklet. Policy requires that responsible staff ensure that this summary is provided annually. Note under Section 708 that recipients are entitled to receive services suited to his or her condition. This generally means that recipients must receive the services that are required via their individual plan of service. Section 708 mandates that recipients are entitled to be treated with dignity and respect by those providing mental health services to them. Section 711 mandates that family members must also be treated with dignity and respect. That is, the right to be treated with dignity and respect applies to both recipients and their family members. Issues around dignity and respect are common recipient rights complaints. Although the Mental Health Code doesn't specifically define dignity and respect, some common definitions include high or special regard, to show consideration or thoughtfulness, to be treated with esteem. Issues related to dignity and respect may include inappropriate tone or manner, inappropriate language, or inappropriate comments or condescending remarks. It's important to point out that limitations to recipient rights must be incorporated into their plan of service. That is, any limitation must be justified on an individualized basis in the plan of service, and only for the reasons permitted by the Mental Health Code and by agency policy. Although not usual, limitations often arise around residence rights, that is, involving recipients who are being provided specialized residential services. Note that the administrative rules require specific documentation around any limitations of the recipient's rights. That is, documentation must include attempts made to avoid the restriction and what actions will be taken as part of the plan to modify or eliminate the need for it in the future. Clearly, any limitation on recipients' rights is a serious matter, which requires a great deal of documentation and justification. Any proposed plan of service which includes restrictions must be submitted to and reviewed by the agency's Behavior Management Review Committee, commonly known as BMRC. Section 726 speaks to communication rights of recipients of residential services. The Mental Health Code states, a resident is entitled to unimpeded, private, and uncensored communication by mail and telephone, and to visit with persons of his or her choice, except under certain circumstances. The right of a resident to communicate by mail or telephone or receive visitors shall not be further limited except as authorized in the resident's individual plan of service. Note the agency policy, communications by mail, telephone, or visits, which further defines the appropriate circumstances under which communication rights may be limited, including in order to prevent serious physical or mental harm, in order to prevent a violation of the law, or if justified in the plan of service with significant supporting evidence and with a documented expiration date. Section 728 speaks to personal property rights of recipients of residential services. The Mental Health Code states, a resident is entitled to receive, possess, and use all personal property. The individual in charge of the plan of service for resident may limit the rights guaranteed if the limitation is essential for one of the following purposes: in order to prevent theft, loss, or destruction of the property, to prevent the resident from physically harming himself, herself, or others. See agency policy for further guidelines related to residents' property rights. Section 748 speaks to recipients' rights to confidentiality, addressed in the accompanying handout and within agency policy. It's very important to review the confidentiality policy in detail in order to have a comprehensive knowledge of the requirements of the Mental Health Code and additional agency requirements. Note that the agency is also bound by the similar requirements of HIPAA. However, often the Mental Health Code requirements are more protective of recipient rights, consequently, they would apply. In terms of client confidentiality, the basic rule of the Mental Health Code is that any information in the record of a recipient and any information gained during the course of providing mental health services to a recipient is confidential and shall not be made open to public inspection. The information may be disclosed outside DCH, CMH, or the contract provider only under certain stated circumstances. The referenced circumstances, or exceptions, are detailed within the agency's confidentiality policy, including when the recipient or his or her legal guardian consents to the release of information to a third party who's requested it, when medical professionals need information in order to provide emergency medical services to a recipient, to a public agency or provider of mental or health services, where there's compelling need for disclosure based upon a substantial probability of harm to the recipient or other individuals. Consultation with the corporate compliance officer is recommended on these cases. Where there is a court order or subpoena. Again, check with the corporate compliance officer related to the receipt of subpoena requests for information. Where it's necessary to comply with law, for example, when there's an investigation by the Office of Recipient Rights or Protective Services. Virtually anything you know about a recipient is knowledge that you acquired in the course of providing mental health services to him or her, and should, of course, be considered highly private and confidential. Even a recipient's identification as a recipient of mental health services, in other words, their name, is considered confidential. Staff must not talk about recipient information to family and friends or others because they're considered members of the public. Internal access to client information is only permitted to those who have a need to know the information in order to perform their job. Staff need to be extremely cautious about faxing client information to the correct place, emailing information, the use of voicemails, etc. Recipients' mental health information should, of course, be treated as we would expect a mental health provider to treat our own private information.